Hello, welcome to the January 2023 edition of Outline. We'll just give it a couple of minutes for people who are joining the live stream to get logged in and settled, and then we'll make a start. We've still got people joining, so we'll just give it another minute for people to get settled, and then we'll get underway. Okay, well, I think most people are probably now logged on, so let's make a start, and welcome again to the January 2023 edition of Outline. So Happy New Year, if it's not too late in the month to say that. And as has become traditional, I think, in January for our Outline sessions, we're going to have a bit of a look back at the case law that came out during the course of last year, back in 2022. And just look at some of the cases that you might have missed, and look at some of the practical points that we ought to all have in mind that come out of those cases as we move forward. I'm joined today by three of my colleagues to talk about their pick of the pops, so to speak, for 2022. Legal Director Claire Stoneman and Associates Henry Jeffries and Alicia Merricks from the team. So morning to you three. Thank you for coming along today. As ever, there is a Q&A button available at the bottom of the screen. If you do have questions, then please do pop them in there, and we will do our best to answer as many of them as we can as we go. If we don't get to your question, then please do, as ever, feel free to reach out to us afterwards and ask us direct. Likewise, if you're watching the recorded version of this on YouTube later, then don't use the Q&A function because we won't respond, but do feel free to get in touch with us afterwards for any questions. But without any further ado, let's get cracking. And Alicia, firstly, welcome to Outline. This is your debut as one of the newer members of the team to Outline, so it's great to have you here. And let's throw you in at the deep end. We'll start with your case, and I think you're going to talk to us about the Barton Park case from the Court of Appeal last year, and it's a case that's looking at what we call the "I'm Your Man" principle. Named after the case, I'm Your Man, that it was first dealt with. One of my favourites, as anyone that's ever been my trainee knows. It's a case I like to talk about a lot. But perhaps, Alicia, before we get into the Barton Park case, could you just remind us what the I'm Your Man principle is that we're dealing with?
Thanks, Trevor. Yeah, sure. So the I'm Your Man case basically said that a limitation on a planning permission, so for example, a time limit on duration or a limit on the hours of permitted use, will be invalid unless it's set out in a planning condition. And that was held to be the case, even if it's expressly stated in the body of the planning permission. So in the case of I'm Your Man, the High Court held that a planning permission which was granted for the use of accommodation for a temporary period of 7 years was actually a permanent permission, because none of the conditions imposed upon it required that use to come to an end after 7 years. And so that principle has since been termed I'm Your Man, as you said, and has been applied in a line of case law since.
I think that's right. It's one that's come up many times in many different cases, doesn't it? But so turning to the Barton Park case, what was happening there? I think if I could sort of summarise the facts, what was going on was the Barton Park were the owner of effectively a caravan site. And that caravan site had the benefit of a planning permission, and the planning permission was quite specific in the description development as to the types and numbers of units that were being permitted under the consent. So I think there were 9 residential caravans, 16 holiday chalets, and then I can't remember how many static caravans and touring caravans, and probably somewhere in there a partridge in a pear tree as well. So you had different types of units, and each one very specific in the description development as to the numbers of those units that were being permitted under the consent. There were then some conditions, and one of those conditions looked to restrict the period of time, the months of the year that the non-residential units could be occupied, so preventing them from becoming full residential units by restricting it to certain months of the year that you could occupy. But I think probably critically what there wasn't was a condition limiting the numbers of units that could be brought on to the site. And so I think what the landowner was trying to do in the Barton Park case was to argue that in effect, planning permission had been granted for a caravan site. And although there were numbers of units referred to in the description of development, there were no conditions that were limiting the numbers that could be brought on. And so what they were arguing was, well, following I'm Your Man, what effectively we have is planning permission for a caravan site. There's no limitation on the numbers of vans that I can bring on, therefore I can bring on as many as I like. And I think they were looking for a lawful development certificate on the facts of the case, weren't they, Alicia, for about 80 residential caravans to be brought onto the site. But I think, Alicia, it's fair to say the Court of Appeal was having none of that, was it?
Yeah, that's exactly right. So in his leading judgments in the Courts of Appeal, Lord Justice Lindblom held that the inspector in Barton Parks had been right to refuse that proposed use of, I think, 80 residential caravans, as you said. And that was because it was held to be a material change of use from that authorised by the Planning Commission, which you've just summarised. And that was held to be the case because it would firstly allow for all of the caravans on the site to be used for permanent residential accommodation with no holiday use at all. And this would therefore bring about a substantial and fundamental change in the character of the site. And Lord Justice Lindblom also analysed that I'm Your Man line of cases in his judgment and emphasised really that the principle wasn't applicable in all instances. And specifically in this case, Barton Parks, it wasn't relevant when considering whether there's been a change of use. Instead, really, the relevant considerations would be, firstly, has the alleged change of use taken place? And then if so, is it a material change of use for planning purposes? And that second question is a matter of fact and degree for the planning inspector to determine, doing so in a common sense way, giving the words in the description of the planning permission their plain meaning and taking into account the conditions. And that determination will only really be challenged by the court where it's deemed to be Wednesbury unreasonable.
I think that's really helpful summary of where the court got to. And I think there's a few sort of takeaways trying to put the practical, we always try to focus on outline on practical consequences. And I think the first point is probably that the Court of Appeal didn't overrule I'm Your Man, did they? So when does the I'm Your Man point about limitations needing to be imposed in conditions? When does that apply now, Alicia? Yeah,
that's right. The Court of Appeal didn't overrule I'm Your Man, and Lord Justice Lindblom actually stressed in his judgment that his analysis didn't conflict with the I'm Your Man principle, primarily because, as we've just discussed, it doesn't apply when determining whether there's been a material change of use. But instead, the I'm Your Man principle will apply where there's been a challenge in respect of the exercise of the same use. And so it is still useful when you're trying to understand whether what has been permitted under a planning permission has been limited. And it's still good law and remains authority for the principle that in order to effect a restriction on a planning permission, that restriction must be set out in a planning condition.
Yeah. So if you're a planning authority and you're looking at if an application comes in for a particular type of development and you want to limit the scope of that permission, it's got to be conditions, and the time limited temporary permission is a classic example because that was the one in I'm Your Man, but there are a number of others, aren't there, if you wanted to limit the scope hours of operation on a business or those sorts of things. It's got to be in conditions. It's not enough to have reference to it in the description of development. But I think that the second interesting point for me in it is this question of what is permitted by a planning permission. And we've seen a number of cases over many years now where the courts have been quite consistent in how you approach the interpretation of a planning permission. And again here, the Court of Appeal made the point that the question as to what has been permitted should be answered by giving the words that are used in the description of development their ordinary plain English meaning, and not trying to read anything too clever into it. And that feels to me that's where Barton Park got it wrong. What was permitted was 9 residential caravans, 16 holiday chalets, and so on. It didn't say at any point planning permission for a caravan site. And so you've got that planning permission for a specific quantum and type of development. If you're then looking to do something as a landowner that is beyond the scope of that description of development, the first question you should be applying your mind to is that going to amount to material change of use? And if it is, it's not about whether there's a limitation. That is a material change of use. Therefore, it constitutes development, and planning permission is required in one form or another. And I think that's a point that for me brings it back to always thinking about what you're applying for planning permission for, and making sure that you've got enough flexibility within your description of development. If you're a landowner, making sure that you've got that flexibility you need to accommodate what you're going to do, because you can't read beyond it too far, I think is the big point that comes out for me. Alongside, Alicia, your point about planning judgment, ultimately the question of whether it is material change of use or not is a matter for planning judgment. And as long as the planning authority or the inspector doesn't get it ridiculously wrong, the courts are not going to interfere with that. So it creates a bit of uncertainty, I guess, in that sense. But get the description of development right. I don't know whether you'd agree, Alicia, but that feels to me like the message that we should take away.
Yeah, absolutely, Trevor. I think, the Court of Appeal in this case have provided very useful clarification, really, that, when they will interpret a planning permission, you're looking at the entirety of what's been said. And as you said, Trevor, giving the words their natural and ordinary meaning. And, in this case, it simply didn't permit just a caravan site. It was for that specific mix set out in the description. And so that really should be borne in mind when interpreting planning permissions.
Yeah. If you apply for permission as a caravan site, then as a local authority, you ought to limit the number of caravans if that's a concern to you by imposition of a condition. But if you apply for 9 caravans, then the planning authority doesn't need to limit, because you've got planning permission for 9 caravans. Yeah. Interesting one. Thank you, Alicia. So where should we go next? Henry, I come to you next if I can. We've done a bit of I'm your man there. Now you're upping the stakes. You've got a Supreme Court case that you've picked to talk about. It's not Hillside. Spoilers for our audience, and it's probably fair to say that Hillside, just in passing, was almost certainly the biggest planning case of last year, and we're deliberately not going to talk about Hillside today. Because we've already done it. We did it on the November outline last year. So anybody that hasn't yet got to grips with Hillside, just as a plug, November's outline is available on YouTube and you ought to watch it. It should be compulsory to know what Hillside means. But that isn't your case. You found another one from the Supreme Court, Henry, you want to talk about, the DB Symmetry case. Now, we did talk about this on a previous outline when it had been in the Court of Appeal, but it's an interesting case around conditions, isn't it? So can we start by looking at the judgment in the case? If you can just remind us briefly, Henry, what was it all about?
Yeah, sure, Trevor. I mean, the Court of Appeal judgment was issued in October 2020. It was actually a couple of years ago we last spoke about it, and the Supreme Court then issued its most recent judgment in December last year. So the 2 issues that the Supreme Court was considering reflected those considered by the Court of Appeal. And the first issue, which is of more general application, was, can a planning condition require the dedication of roads as public highways? And then the second question considered by the Supreme Court was, did the condition in this particular case require dedication or not? So the council's position on the first point was that, yes, a planning condition could require dedication legally. And then the second point, council's position was that the condition that they imposed did purport to require dedication. And then we had the developer and the Secretary of State taking the opposite position. So in terms of the facts, I won't go into a great amount of detail, but I think it's useful to understand the site slightly. So the developer's site was one of a series of sites to the northeast of Swindon. And the intention was for the scheme comprising the full set of sites to be joined together by a series of access roads. Now, the developer's site was accessed from the A420, and as a result, the other sites were accessed through the developer's site. So the council were keen to ensure that access was provided to the remaining sites. And the way they tried to do this was by the imposition of a condition. The developer originally applied for, having secured planning permission, applied for a certificate of lawfulness to state that the access roads through its site could be used as private access roads as opposed to public highway. And from a commercial perspective, the reason for that was that they could then seek to impose a charge on the sites further down the chain, if you like, to use their access roads to access their sites. The council refused the application for a certificate of lawfulness on the grounds that this condition required the roads to be made up to and adopted as public highway. I won't read the condition in full because I don't think it's especially relevant, but the point is that it didn't refer to adoption as public highway, it referred to highway in a broader sense. And in terms of considering the second question, I think that's relevant. So before we get to the Supreme Court, the decisions went back and forth ever so slightly. So the inspector in the first instance was only focusing on the interpretation of the condition, and they found that the condition didn't require dedication as public highway. When we got to the High Court found that the condition did require dedication as public highway, and then we got to the Court of Appeal where they reverted back to the inspector's interpretation, then also introduced this question as to, can a planning condition lawfully require dedication as public highway? And that's where we were left prior to the Supreme Court's judgment.
And it's probably it's the new question, isn't it, that I think is most relevant. But just put us all out of our misery before we get to the new question. In terms of whether the particular wording did, I think ultimately it's a similar point, isn't it, to the one that I've just talked about with Alicia and Barton Park. The court said it's you give the words their ordinary plain English meaning and conclude accordingly, didn't they?
That's right. And the Supreme Court actually gave 6 reasons for their interpretation of the condition. And so, to put you out of your misery, as you say, the conclusion they came to was that the condition didn't require dedication as public highway. I mean, interestingly, one of the things they looked at in coming to that conclusion was the policy position and also the practice position as well, in terms of what do local planning authorities tend to do. And in particular, they looked at the NPPF and NPPG, which actually includes an express line which says conditions should not require developers to give lands to other parties, including highway authorities. So the policy position is already fairly clear, and the court actually used that in their interpretation of the condition.
Thank you. But the bigger point, I think, as a result of it, it might have been a late entry to the dispute, but it has quite wide application. I think is this question of whether a condition can require dedication of land as highway. So where did the court get to on that?
Quite an interesting analysis, because the start point is section 70 and section 72 of the 1990 Act, which are the sections that deal with the ability to impose conditions on planning permissions. And the power there isn't limited. So it's a fairly broad power. And even the provisions under section 72 are expressed as being without prejudice to the general power to impose a condition. So where the court went with it was to look at the general principle that the provisions of the 1990 Act should be read in the context of the Act as a whole. And in doing that, they looked in particular at section 106, so planning obligations, and also the sections dealing with compulsory acquisition of land by the local authority. And where they got to was that those other powers provided the means to require dedication as highway, so either by section 106 agreement or through compulsory acquisition and then the subsequent payment of compensation. And in actual fact, it's those other two routes which should be used. And the point which the court focused on was the fact that with a 106 agreement, it is voluntary on the part of the developer. So there's the scope for negotiation there. And then with the compulsory purchase powers, there's the payment of compensation. And they contrasted that with the unilateral imposition of a planning condition, and essentially found that as a result, the imposition of planning condition requiring dedication was unlawful.
And I think that kind of takes us to the sort of so what, doesn't it? It seems to me that they're in that. So, okay, firstly, now we know you cannot require dedication of land as highway under a condition. And that comes up quite a lot, I think, in my experience. You do see conditions, particularly in exactly the scenario you've outlined that applied here, where you've got later developments coming forward that will need to come through that, through the access that's being constructed as part of a current development. Obviously, a developer would quite like not to dedicate it because that creates a ransom over the development. A local authority that's keen to see delivery will take a different view. So we now know if the local authority is trying to prevent that, they've got to do it by 106 rather than by conditions. But it feels to me, as well as that quite specific scenario, there's a broader principle, isn't there, about the limitation on the use of planning conditions that we all ought to be aware of as we're moving forward, negotiating planning permissions and imposing conditions on them.
I think there is, and actually the judgment provides quite a useful summary of the tests for the imposition of planning conditions. So it goes back to the Newbury case, looking at the 3 tests under Newbury, which are that the conditions imposed for a planning purpose, it fairly and reasonably relates to development, and it's not so unreasonable that no reasonable planning authority would have imposed it. So Wednesbury again. So there is a wider application, and I think the point to bear in mind is that while that power to impose conditions is broad, the court doesn't see that as a carte blanche for the imposition of any condition. There are tests, and actually, when you drill down to it, the specific tests in relation to highway, looking at the wider application of the Act, that approach, I think, applies across a number of topics, not just highways. And on the point around using a Section 106, the court expressly acknowledges that that's a route that can be taken. And I think actually on the facts of this case, it's potentially an omission on the part of the council rather than an intentional approach of using the condition to require dedication. So it feels almost like it's an engineering after the fact rather than the approach that was intended from the outset.
Yeah. Okay. And so moving forward, if you're wanting to ensure that estate roads are dedicated as highway in due course, then the answer is 106, isn't it? Not conditions.
It is, yeah, and obviously following the 106, there'd be a Section 38 agreement under the Highways Act to actually secure that dedication.
Yeah. We've had a question come through, Henry. So before I move on from you, I'm not going to let you off the hook just yet. And in one of your areas that you're particularly hot on, which is sort of BNG and all things connected. So the question is, if could you use a planning condition to secure an off-site biodiversity offsetting area, or would you have a similar issue there?
I suppose there are two different answers, aren't there? There's the pre coming into the force of the Environment Act provisions answer, and there's the post coming into force answer. So in terms of the post coming into force answer, and at the moment we're expecting November of this year to be the date for that, there'll be a deemed planning condition requiring a biodiversity gain plan to be approved by the local planning authority prior to commencement of the permission. And it's that plan and compliance with that plan under the deemed condition which would secure any off-site biodiversity gain. So the answer is yes, but it would be by way of that deemed condition and then the subsequent compliance with it. Pre-Environment Act, I don't see any reason why not. I suppose the difference there would be that the requirement for off-site biodiversity gain would come from policy as opposed to from statute. So it would be a question of what's in the local planning authority's policy where the development site's located.
I think that I agree with that, and I think the other thing that it might depend on is what is it the conditions requiring. If it's requiring you to use that land for offsetting, that feels to me that sits fairly comfortably within a condition. If it was trying to require you to transfer that land to another, then you start to come into the same problems of requiring dealing with land via a condition rather than just controlling use of land. So for me, I think that would be the other point I'd add to your answer, is just depend on what it is. Because I think, coming back to DB Symmetry, there doesn't seem to me there's any question that the roads need to be used as roads. The question is about whether the land interest needed to be surrendered to an extent by dedicating the land as highway and effectively surrendering your private rights as landowner to your own land. It seems that that's part of the difference, which in the questions example would come up if they were asking you to transfer the land to another body, but wouldn't come up if they were just saying you need to use that land in a particular way in order to offset the effects of the development, perhaps. Yeah, agreed. And that transfer of land point goes back again to the policy position as well, and with the MPPG, which is referred to in the DB Symmetry case. Yeah. Great. Thank you. And then Claire, last but by no means least, and who knows, maybe we saved the best till last. You certainly saved the one till last that scares me, I think it's fair to say, which is the Finch case. And I think, again, we have talked about the Finch case previously, but it's now been through the Court of Appeal. And this is the one that is the challenge, or say it is a challenge to a grant of planning permission on the basis of an EIA point. Still a fertile ground for challenges to planning permissions is the EIA regime. But could you just, I know we've talked about it before, but could you just sort of start by briefly reminding us what it was all about? Because it's quite unusual in terms of the development and the point that's being taken, isn't it?
Yeah, of course. So the case relates to a decision by Surrey County Council to grant planning permission for development which comprised the retention and extension of an existing well site, as well as the drilling of 4 new hydrocarbon wells. And the project was going to be for the extraction of crude oil over a period of about 25 years, which once extracted would then be taken by tankers to refineries for processing to then become fuel. And it was not clear where the oil would be refined or where the fuel may be used, whether that would be within the UK or worldwide. And when the council adopted its screening opinion, it said that the developer's environmental statement should consider the global warming potential of the oil and gas that would be produced by the proposed site. But then when the developer actually submitted its ES, it only assessed the emissions resulting from the construction and operation of the development itself over its lifetime. It didn't look any wider than that. And it argued within the environmental statement, and it's an argument that the council accepted, that there was no need to look at the global warming potential of the oil because, first of all, the essential character of the development was extraction and production of hydrocarbons and not how they were then used. And then secondly, because national policy and guidance establishes that decision makers should focus on whether the development is an acceptable use of land, rather than on the control of emissions, which are subject to separate pollution control regimes. And then what happened was Sarah Finch challenged that decision on the basis that granting planning permission for development, which is extraction of oil, means that it's inevitable that that oil will be used in a way which generates greenhouse gas emissions, and therefore it was legally a requirement that such emissions should have been assessed within the ES itself.
And I think ultimately the court's come to the same conclusion as the High Court decision that we've discussed previously on Outline, but the Court of Appeal got there by a different route, didn't it? And I think for me, the way it got there has different implications for the scope of environmental impact assessment more generally, does it not?
Yeah, so the Court of Appeal dismissed the appeal and agreed with the decision of the High Court, but for different reasons. And I think it's helpful to start to look at first at what was decided in the High Court. So in the High Court, Mr. Justice Holgate found that downstream emissions could not, as a matter of law, be an effect of the development for the purposes of EIA, and therefore they didn't need to be taken account of in the ES. And he also held that the legal test of whether an effect constitutes an indirect, likely significant effect is whether an effect on the environment is an effect of the development for which planning permission sought. And I think there was probably a sigh of relief at that point from developers when that decision came out. And Sarah Finch appealed that to the Court of Appeal, arguing that the interpretation was incorrect. And the Court of Appeal actually disagreed with Mr. Justice Holgate and said that such impacts, it wasn't right to say that such impacts were legally incapable of being in effect, which required assessment. And instead, the test was whether, that the question was not, it couldn't be put into a direct legal test. It was a question as to whether any likely significant effect was direct or indirect of the proposed development needed an assessment of the degree of connection between the development and its effects. And they disagreed with Mr. Justice Holgate, saying that emissions were incapable of being assessed as a matter of law, and instead said that it was a matter of fact and judgment for a local planning authority. So in the present circumstances, they decided that looking at the project and what was involved, that the environmental effects of the emissions could reasonably be seen as being far removed from the development, because there would be a series of intervening stages between the extraction of the crude oil and the ultimate generation of emissions. It would have to be distributed, refined, sold, and then used. So it couldn't directly be seen to be an indirect effect of that development. And when they then considered what information should be included in an environmental statement and whether that was adequate for the relevant planning authority to make its decision, it again went back to that Wensbury and reasonableness test that we've discussed in the other cases. One thing to point out is that there was a dissent in judgment from Lord Justice Moyland here, and he held that the council's decision was unlawful, and that in the circumstances, the EIA should have included an assessment of the emissions as they were an inevitable impact of the project, and the council's reasons for excluding them were legally flawed. So I think it's interesting that the Court of Appeal itself can't decide whether effects are inevitable or reasonably attached to the project, so that they should be assessed or not.
Definitely, if you've got three judges in the Court of Appeal and two of them go one way, one go the other, that's quite unusual. The court tries to make sure its decisions are unanimous, and that is in itself an alarm bell. That clearly there is a school of thought within the judiciary at a quite senior level that potentially these sorts of factors should come in. But just sort of pausing on the judgment, because the leading judgment did reject Sarah Finch's challenge. But what's the key takeaway then? Because I suspect there aren't many that are going to be listening to this who are planning on applying for permission for extraction of oil. It's not a development that comes across our desks very often. But what's the key takeaway for everyone that's putting together EIAs and thinking about these issues around climate change and carbon emissions?
Well, I think although the claim of Ms. Finch was dismissed, the judgment of the Court of Appeal has really reopened the door for objectors to seek to argue that indirect effects should fall within the scope of the EIA. And the difficulty is that with the Court of Appeal saying that it's not a legal test as to whether effects need to be considered or not, it ends up being a matter for decision makers to grapple with. So for anyone acting for a local authority here, it's really important to make sure that reasons for decision taking are clearly articulated and recorded, because I think Surrey just about got away with it here in terms of their decision making, but the assessment was that the reasons just about passed muster, so it wasn't really a glowing review of the way in which they'd handled things.
When the court says this is planning judgment, that's key for we don't want to. It's code, isn't it? But we don't want to be second guessing decision makers on this, as long as they've done it in a robust way. And I suppose that's helpful in that if your decision maker concludes it's not necessary in a particular case, then you've got a reasonable degree of comfort. As long as they've done that properly and they've set out their reasons fully, then you know you're going to be sort of less vulnerable to a challenge. But of course, it does also mean if they say that they do think it's relevant in a particular case, then you're sort of stuck with it, because again, the court's not going to intervene to change minds. And I do sort of think, yeah, I don't know, I'm trying to think of some examples, but given what you said about the court sort of saying that there are a number of steps between the extraction of the oil and ultimately what happens to it, and therefore what the emissions might be from its use, you can see scenarios. I'm thinking manufacturing, for example. If you were applying for planning permission for, I don't know, a new car plant, you know that the cars that are going to be coming off that production line, or you know what their emissions are going to be. It's going to be because that's measured and published, isn't it? So in that scenario, can you see a situation, Claire, where potentially a decision maker could say, actually, I want the impact of the cars coming off this production line being driven forming part of the assessment? I think that feels like it is the logic of what the Court of Appeal is saying, isn't it?
Yeah, I think so. I mean, the Court of Appeal said that it wouldn't be helpful to start giving examples of where wider assessment would be appropriate, but I think you're right in saying that any development where it's going to involve the production of raw materials which are then used in a subsequent manufacturing process, for example, will lead to an end product where you've got emissions at each stage, and where you're talking about something like vehicles, you then have an ultimate product which is going to cause emissions of its own right. And I think it's going to be inevitable that at some level, despite the best will in the world, because the decision making is left to the judgment of local planning authorities, there's going to be a lot of uncertainty and inconsistency in how this is dealt with in environmental statements. And I think for developers who are undertaking EIA development, it means that the scoping process for EIA is probably going to become more important as they try and agree with the local authority some clarity on what indirect effects do need to be scoped into the environmental assessment.
Yeah. So as things stand at the moment, don't ignore those effects. You've got to scope them out, or scope them in, I suppose. But if you ignore them, that's where you're going to be vulnerable, isn't it? Is if you try to just stick your head in the sand with it. But there's more to come, isn't there? Because the Supreme Court has granted permission for an appeal. So we're going to get, presumably later this year, I guess, Claire, we're going to get the Supreme Court's view on this question. And I think that, for me, that's where the dissenting judgment in the Court of Appeal is a red flag, because it suggests that there is a question there in the minds of the judiciary that might yet be the majority view in the Supreme Court, I guess.
Yeah, I think that's right. So at this stage, we understand that the Supreme Court hearings listed provisionally for June. So everyone will be waiting to see what the Supreme Court has to say on the point. And I think one thing which is interesting about the case as well is it starts to call into question what role the planning system should play in helping to regulate greenhouse gas emissions. And it's interesting to consider, I think, whether it's really to the extent to which it's set up to do that, and how far it should be playing a role. Yeah,
there's a question for others in another place, as they say, to ponder. But it's a very fair point. But in the meantime, until we know what the Supreme Court says, the Court of Appeal's decision is the law, and therefore I think the key takeaway is don't ignore those sorts of effects. Make sure they're addressed through scoping one way or the other. And let's see where the Supreme Court takes us. Great, well, thank you. That brings us to the end of this session of Outline. So if I can just sort of end by thanking Alicia, Henry and Claire for coming along and giving us their thoughts on their cases of 2022. As I say, the other one that we must acknowledge is Hillside, but see November's outline, November 22's outline for an in-depth discussion of Hillside and why everyone in the planning system ought to know what it says. We'll be back in February. The live broadcast of Outline in February is on the 23rd, when I'll be joined by Sophie Stewart and Peter Clausen, and we're going to be looking at a bit of a masterclass on all things connected to variations of planning permissions and dealing with conditions on planning permissions, and looking at some of the practical real life examples of where these things can go wrong the consequences when they do go wrong, and most importantly, how to make sure they don't go wrong in the first place. So that's what we'll be talking about in February. In the meantime, we will make sure that all the cases we've referred to today will include links in the email to those who have attended the live stream. They'll also be posted in the description on YouTube. All previous editions of Outline are there for you to peruse at leisure, so you can go back and see whether what we said about Finch and the High Court bears any relation to what we're now saying about Finch today in the Court of Appeal, and likewise with DB Symmetry. But other than that, thank you to everyone for attending, and goodbye.